Welcome to Bloomberg Law. I'm Lee Pacchia. On January 4th, President Obama established Richard Cordray as the director of the newly formed Consumer Financial Protection Bureau by way of a recess appointment. This move has generated controversy, and certain business groups and politicians continue to remain opposed to this appointment. Joining me now to discuss is Rori Cassirer. She's managing partner at Troutman Sanders New York and New Jersey offices. Did I get your name right?
You did. Thank
Good.
you.
Every time you come
great.
on here, I botch your name, and I feel so bad about it. But welcome back. Great to see you.
Thank you so much.
So we're off to 2012. New director of a new agency, not brand new, but relatively new in terms of things. I think we can call it new. Let's figure out what's at stake. Practically speaking, what does this appointment mean for the banks?
For the banks, not much, because the CFPB has already been after the banks. They had the power to do that since July. Mm-hmm. What it does have enormous meaning for is the non-banks.
Right, we have the non-bank supervision program.
Correct.
What's in there?
What's in there? What's not in there is the better question. Mm-hmm. You have mortgage brokers, mortgage bankers, insurance brokers, cash, credit card companies, cash check companies, payday lenders, student loan providers. It's a whole grab bag of things.
And I love at the end of the list, there's this catch-all. Forgive me, I don't know verbatim, but it's something to the effect, and any company that supports any of the companies aforementioned. So it's expansive. It really means non-bank. So,
it's an unbelievably broad legislation.
Okay, so all these entities out there are expecting a change in life, right? What's going to be different now?
They're going to be subject to lots more regulation, lots more scrutiny. They were always subject to some scrutiny. It was spread out over the FTC, over the Justice Department, over the SEC, over the state attorney generals. At this point, it's all consolidated with Mr. Cordray, who is a former prosecutor. Mm-hmm. And his mandate is to promote regulation, compliance. He has subpoena powers. He has power to enforce regulations that he's going to promote. And all of this, of course, is done with a recess appointment. Mm-hmm.
So we're going to get to the recess appointment in a second, okay. But we have a little bit of an indication as to how Mr. Cordray is going to operate. He's only been in power for about a week or two now, but
January 4th.
January 4th, so that's 2 weeks.
Right.
Exactly. So we have this one case that we were talking about before we jumped on. It's in New Jersey. It's a mortgage company.
It's a mortgage company that was notified by Mr. Cordray's agency that they are being scrutinized for insurance kickback practices, allegedly stemming out of kickbacks received out of title insurance proceeds. They had some sort of captive insurance company. They stopped that practice in 2009, interestingly enough. Mm-hmm. They were subject to a class action. HUD could have handled this case, but that's the first action that Mr. Cordray took under his new powers.
Interesting. We'll have to see how that plays out. Let's talk about the legality of the appointment. A lot of people, in theory, are saying that they're opposed. Can anyone realistically enter a legal challenge?
Oh, I think this is a very vulnerable proposition. Under the recess appointment powers, the president can appoint somebody, and he appointed 4 people in this case, 3 commissioners to the NLRB and Mr. Cordray to
all on the same day.
All on the same day. And Mr. Cordray to head the Consumer Protection Bureau, and he calls him a watchdog, but it's more than that. The recess appointment theoretically can be exercised only when the Senate is in recess. Question, was the Senate in recess?
Right.
The reality is that for the past 10 years, what the senators have been doing and what's been done, this was actually a device invented by the Democrats, not the Republicans, and they've used it very successfully since. What they've done is never gone into recess. Essentially, they recess for 3 days. On the 4th day, somebody comes in, bangs the gavel, and they're in session. And then a few minutes later, they bang the gavel, they end the session, and keep repeating this. And they've been doing this since December 17th, when they went off for Christmas. They're supposed to resume again towards the end of January. But in fact, who decides whether the Senate is in recess? The Senate normally decides who's in recess. Very interesting, because I've been looking at the facts surrounding this one. Senator Kennedy staff actually wrote an amicus brief in a case where the Senate was in recess for 10 days, quote unquote, not in recess. They just weren't in session for 10 days. And he said 10 days doesn't mean there's a recess. somebody's going to have to decide whether 3 days is a recess or whether it's not. In addition, so if the Senate was not in recess and this appointment is found to be invalid, then any regulations that were promulgated during the pendency of this appointment or the term of this appointment will be found invalid too.
Have to be rolled back, presumptively.
Have to be rolled back, and that's what happened with the NLRB.
So you think we're going to see a challenge, and if so, who would have standing to bring it?
We will definitely see a challenge. Anybody who's hurt by the law, for example, this mortgage broker might have standing to pursue it and bring the invalidity argument.
The intersection of law and politics, I love it.
Isn't
and of
it
course,
amazing?
This is all happening in an election year. It's 2012, we're going into an election. How do you expect, this issue notwithstanding, say the appointment is upheld and they go forth and do whatever the Consumer Financial Protection Bureau wants to do. How do you see them acting and operating in an election year? It's
I think
unusual.
It's very clear. I think they're going to start bringing actions against various businesses. I think they're going to promulgate laws. I think they're going to look at a lot of the consumer issues. I think one of the things that we discussed earlier is the credit card issue. Mm-hmm. I mean, I think that's something that's sort of, it affects each and every one of us.
Right, it's a very busy time in the credit card space, too.
Let's look at the fees. How does this,
Right. The interchange fee class actions that are out there now, they're just talking about massive sums in terms of potential damages. You expect them to jump in there next, do you think?
I expect them to jump in there at some point during the next year. I expect them to jump into the student loan area. I expect them to jump into the disclosure of mortgage fees area. I think this is going to be an extremely busy agency. I think this is a very powerful agency. So, and I think they're going to make full use of their powers.
And it's fascinating that we have a former aggressive prosecutor sitting in the director's chair. It's going to be a busy year, and I hope you can come back and fill us in on developments as they come to pass.
I hope you ask me. Thank you.
Rory, thanks so much.
Thanks a lot, Lee.
That's Rori Cassirer. She's a managing partner at the law firm Troutman Sanders. If you'd like to learn more about the cases and issues we just discussed, go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. I'm Lee Pacchia. Thanks for watching.